Yeah, absolutely.
Council ready?
Yes. What's the big deal? $19 million to salvage this thing. I saw it. It's the size of a huge jet. It's designed to take out a ship, and it's not. It's 100 meters away from producing oil. Yeah. You saw it on site visits.
All right.
Yes, Mr. Black.
Thank you, Your Excellency.
You have to address the court.
May it please you, we say there are essentially four preliminary issues. The first is this, that the factual basis upon which the freezing order was granted against Straight is not in dispute. We say that the court can, and indeed in our respectful submission is obliged to, work on the basis that Straight is indeed no more than a cipher and alter ego of Mr. Akhmedov, formed for the sole purpose of evading enforcement of the English judgment against him. Indeed, when the judgment was given on the 20th of December 2016, it was at that stage that the company Cubo 2 owned the yacht. And Cubo 2 was held, of course, by the judgment to be Mr. Akhmedov, to be his alter ego. And yet in March of 2017, Cubo 2, aka Mr. Akhmedov, transferred the yacht to Straight. Now that's not in dispute. So Straight got the yacht directly from Mr. Akhmedov. And Mr. Flynn took you to the Liechtenstein freezing order. You may recollect he did that before the short adjournment. He probably was quite unaware that he was on extremely dangerous ground when he did that, because the transfer to Straight was in breach of that Liechtenstein freezing order. And what is clear from the evidence, and I checked it over lunch to make sure that I'm right about this, Cubo 2, the company that breached the Liechtenstein freezing order, surprise, surprise, is run by the very same people who run Straight. They go out of the same office, and in particular, Dr. I think he is Shirley, who is the deponent in this case. So Straight is run by the very same people
But
who...
first of all, Cubo was found to be Mr. Akhmedov's
Yes.
establishment.
Yes.
Yeah.
So QO2 is run by the very same people who assisted Mr. Akhmedov in the transfer of the yacht in breach of the Liechtenstein freezing order to Straight. So we're asked, why are we here rather than Liechtenstein? Two reasons. We can't trust Straight to observe a Liechtenstein freezing order because the same people didn't do so when they were managing QO2. And secondly, to use an English expression, of course, possession is 9/10 of the law, and the asset is here. That's why we are freezing it. That's why we are freezing it here. And there are, we say, good grounds for freezing it. I'll come to those in a moment. The second preliminary point is it is not in dispute as a matter of fact that if Mrs. Akhmedova is successful in obtaining a DIFC judgment against Mr. Akhmedov, enforcing the English judgment, there is good reason to suppose that either Mr. Akhmedov can be forced to use the assets of Straight to satisfy the judgment, or there is a process of enforcement by which Mrs. Akhmedova can obtain recourse against the assets held by Straight. That is not disputed as a matter of fact. It is perhaps surprising that Straight has chosen not to dispute those facts, but it's its own choice, and as we have seen, it has available the best possible legal advice in the form of my learned friends and their instructing lawyers. And we say that it cannot be said that these are issues for another day, because each of these issues has a direct bearing on the court's jurisdiction, as we will demonstrate. Thirdly, and my learned friend was correct to say this, we do say that the jurisdictional challenge is formally invalid. Straight, yes, puts some evidence in, it's accepted that it's done that in a formal sense, but it has put no evidence dealing with the real issues affecting jurisdiction. And so it's not a mere technicality. The fact is that the DIFC court is a unique court, or at least it was until other courts copied it in nearby jurisdictions, and it deals with jurisdiction in a unique way. Under RDC 9.53 to 56, service is decoupled from jurisdiction. That's contrary to the English procedure and those jurisdictions that follow the English procedure. In the DIFC, as long as service is made in accordance with the rules, it is then for the defendant to dispute jurisdiction in accordance with Part 12 of the RDC. And so he must make an application. And it is trite that he who makes an application must prove it. And that is why the evidence must be, that's why the application must be supported by evidence. And that is why the evidence must go to the issue of jurisdiction. The second defendant has filed no evidence that goes to the basis of the jurisdiction of this court over it. Namely, that it is merely the first defendant wearing yet another mask to hide himself from the eyes of the law. We say the reasons that it has filed no evidence are obvious. No one is willing on behalf of Straight to come along and lie to the court that Straight is any more than a device created by Mr. Akhmedov to evade his judgment debt. And so we have this convoluted and technical argument that is in fact devoid of any factual or legal merit, as we will demonstrate. Because the fourth point is Straight's legal submissions are simply misconceived as a matter of law. We are grateful for the concession that my learned friend made in his oral submissions that it doesn't matter what you call the question of jurisdiction. He's rather moved away from, I think, the confusion that was caused by the way in which the skeleton was drafted in making a distinction between substantive and territorial jurisdiction. I think we may well be on the same page. Whether you call it substantive or territorial, jurisdiction, properly called jurisdiction, is found in Article 5 of the Judicial Authority Law. What he had previously called substantive jurisdiction, i.e. the power, and I'll call it the power to make an interim injunction, is obviously found in the court law, and we'll come to that. So in my submission, I will refer to jurisdiction, meaning properly jurisdiction under the JAL, and I will refer to power, meaning properly the jurisdiction to grant injunctions, the power to grant injunctions. The other dangerous area that my learned friend strayed onto, perhaps unnecessarily, was that he did submit that Straight had complied with the order and disclosed its assets. And indeed, there is a witness statement from Dr. Shirley, which says that Straight doesn't have any assets other than the boat. I wonder if you'd be kind enough, please, to take up my learned friend's bundle B, and you will find his witness statement at, forgive me, tab 9. Tab 9 is page 33, I'm sorry.
33.
Yes. And I'd like to go to the second page, if I may. At paragraph 6, he says this: I can confirm that the second defendant is the owner of the motor yacht, etc., that the Luna is the defendant's only asset over $10,000. Luna is currently located in the dry docks. The insurance value of Luna was $486 million odd. And so he felt able to submit to you that, in fact, his client had complied with the order that Your Excellency made on the without notice application. Can I just take you to that, if you would? That is in the same bundle at tab 1. And if you'd please turn to page 4 behind tab 1, you'll see paragraph 7 of the freezing order, which says that this order does not prohibit the respondent from spending $2,000 a week towards his ordinary living expenses and also a reasonable sum on legal advice and representation. But before spending any money, the respondent must tell the applicant's legal representatives where the money is to come from. Well, they're in breach of that, because clearly they have spent money on legal advisors, and we have not been informed of that. And indeed, knowing my learned friend as well as I do, I'm sure he cost rather more than $10,000 to attend here in this court, and therefore there has to be sums available to Straight greater than $10,000, and therefore Dr. Shirley's witness statement would appear not to be entirely accurate in the circumstances. Again, that was, as I say, a dangerous area upon which my friend perhaps inadvertently strayed. Moving then back, if I may, to the substance of his submission. The thrust of his submission is this, that he claims that the only way in which I can assert jurisdiction is on the basis of a judgment, and a final judgment against Straight, and that the claimant simply can't just make a claim. We say that is complete and meretricious nonsense, because Article 5 of the Judicial Authority Law is all about claims. And if you go to the bundle that we were looking at before, in which Article 5 is contained, so that was the original ex parte bundle of authorities at page 674, you'll see there, again, you're very familiar with it, and he has taken you to it on a couple of occasions. But, and this becomes important later on too, but Article 5, A1, A through E, is all framed in terms of claims, including E, any claim or action which the courts have jurisdiction in accordance with D Ifc laws and D Ifc regulations. So let's just have a look at what claim has been made in this case. You will find the claim in the particulars of claim. And they are in Bundle B, that my learned friend has prepared. You'll find that behind tab 5. In their bundle. And the claim against Straight is at internal page 4 of the particulars of claim, page 28.7 of the bundle.
Right.
And that's heading there, claim for declaratory relief and judgment against second defendant. And certain facts are set out there about, under paragraph 21, about the yacht, its transfer from the first defendant to Tiffany, from Tiffany to Avenger, and then from Avenger to Woodblade, and then there's a question of the imposition of a Bermuda trust, and then there's a transfer. Then there was Avenger, was the registered owner, and then the transfer. And then all those transfers were set aside by the English court, paragraph 22. But 23, unknown to the English court, at the time of the final hearing, the first defendant took further steps with the deliberate intention of evading and frustrating the judgment. 30th November 2016, the ship was re-registered with the Marshall Islands, and there was a transfer from Avenger to Stern. And then on the 1st of December, there was a transfer from Stern to Cubo 2. So Cubo 2, as I said before, you see at 24.1, was held by the English court to be no more than Mr. Akhmedov himself. And then, after the making of the judgment at paragraph 26, we refer to the 8th of March, the first defendant caused or procured the transfer from Cubo 2 to the second defendant. And so we plead the first defendant is the true owner and controlling mind of the second defendant. We plead that Straight is a bare trustee. Further, or alternatively, the purchase of Luna, the money was provided solely by the first defendant personally, as we say also in relation to Straight's legal fees now, and it's presumed that Avenger, Stern, Cubo 2 each held and the second defendant holds Luna on resulting trust. Further, alternatively, the first defendant has separate legal personality, the second defendant with deliberate intention of evading and frustrating the enforcement of the English judgment, such as separate legal personality of the second defendant should be disregarded. So pierce of the corporate veil, and accordingly judgment is sought against the second defendant joint and severally the first defendant. So there is a direct claim, unlike many of the cases that have been referred to by my friend, there is a direct claim in this court against Straight, It is a claim that asserts facts which we say would justify this court in piercing the corporate veil, in setting aside, in disregarding the separate legal personality and finding that Straight is simply a mask behind which the first defendant is hiding. And we say that it is only necessary for the purposes of jurisdiction to show that we have a good arguable case on that basis, that we will succeed with the claim. We don't, in fact, even need the English judgment for this purpose. It is not a necessary condition of these proceedings. If this court were to uphold the pleaded claim there against Straight, then clearly there would be a judgment in this court against Straight. And for the purpose of jurisdiction, jurisdiction is based on claims. And this is the claim that we make. For the purpose of the power to make an injunction, we have to show a good arguable case. We say the evidence abundantly shows there is a good arguable case that we will succeed on that claim. So we say that we're not...
Sir, Mr. Black, you're saying to establish the jurisdiction you need good arguable case, or just to get the freezing you need good arguable case?
To get a freezing, we need a good arguable case.
Yes, but to find the jurisdiction, you need a real link. Jurisdictional link. That's
yes,
how it works.
to find the jurisdiction, we have to have a claim which falls within the jurisdiction of the court.
Right.
We say that there is a claim that falls in the jurisdiction of the court because we are seeking to enforce the English judgment, not a judgment against Straight, but we're seeking to enforce the English judgment that has been made against Mr. Akhmedov because we say that Straight is Mr. Akhmedov. That is an issue of fact to be tried in this court. And we say there is a good arguable case that we will succeed in that issue of fact, and therefore the injunction should lie. So to make my distinction between jurisdiction and power, there is jurisdiction because there is a claim that falls within a procedural gateway.
Are you saying that unless the court find against the fact that D1 is not T2, then there is no jurisdiction for D2 to come under this jurisdiction?
If the court finds on evidence that D2 is not D1, then there would be no jurisdiction. But for the purpose of today, what I need to show you for the purpose of jurisdiction is that I have a claim phrase which falls within the jurisdictional gateway. I do that by my claim that Straight is Akhmedov and Akhmedov is Straight. It's then for my learned friends to show that that is unarguable. They need to lead evidence to say that that is unarguable. They need no evidence whatsoever. And so this court actually is obliged, we say, to proceed on the basis of the only evidence before it, which is strongly arguable that Straight is indeed Akhmedov. And so we say there is clear jurisdiction. The next question then is whether the court should exercise the power to grant an interim freezing order. And we say I have to show a good arguable case in order to persuade the court to grant an interim freezing order. And we say we have done that. We did that on the without notice proceedings. There's no evidence to contradict what we said, and that position remains as it was when we appeared before you before. And my little friend seems to be objecting to the idea that you can bring proceedings in the D Ifc against anyone, anywhere. But you can. That's the scheme here. There is no, unlike all of the English cases that Madame Friend has been put before you, you can serve out of this jurisdiction, and the burden then passes to the defendant to make an application under RDC Part 12, and by evidence show that there is no jurisdiction. Now, he may not like, as the person who was here the other day, may not like the system here, but that's tough. That is the system that we have had for the last 10 years, longer, in this jurisdiction. And it may be a unique feature, and there may be interesting academic arguments about whether that jurisdiction is a good thing or a bad thing. But the fact is, that is the way in which this court operates. So then, if I may, with those prefatory remarks directed at the way my learned friend has put the case, can I then turn to dealing in slightly more detail, particularly with the arguments that appear in its skeleton. And indeed, Section B of its skeleton says nothing at all about the background and does not address Claimant's case that Straight is Akhmedov, and Akhmedov is Straight. And my learned friend, is oral submissions.
Excuse me?
My learned friend, in his oral submissions, has not addressed you on that issue at all. We are still then in the position, we say, that we were when we came before you, that there is a good arguable case that is so. We accept that where an order has been made without notice, and the matter comes back before the court, the claimant must demonstrate that she is entitled to the relief claimed. We say that's easy in this case because there is no challenge to the right to the relief claimed, save for the question of jurisdiction. The unchallenged facts are as strong now as they were at the without notice hearing. And clearly they justified the grant of the injunction that was given then, and subject to the jurisdictional challenge now, they continue to justify the grant of that relief today. So the thrust of my learned friend's submission, both orally and in writing, is that the claimant's claim is not an enforcement claim. We say that is simply not true. Straight is the alter ego of Mr. Akhmedov. He is the judgment debtor. Therefore, the claim is to enforce a judgment debt. It is also a claim against Straight. And that is why all the other companies that have been used by Mr. Akhmedov have been declared to be his alter ego and made jointly and severally liable with him. It took you to that in the original judgment and the order. And we seek the same relief here. We seek the same relief that Straight be made jointly and severally liable with the first defendant. That's paragraph 29 of our particulars of claim. And it is significant, as I noted at the beginning of my submission, that it was Cubo 2 that transferred the yacht to Straight. So it was, since Cubo 2 has been held by the English courts to be Mr. Akhmedov, it was Mr. Akhmedov who transferred the yacht to Straight. And nobody, and Straight has not come forward and put any evidence before the court to show, for example, that Straight actually paid any money for the yacht, that it wasn't a simple gratuitous transfer. And so the court is justified. The court is justified on working on the basis that it was simply a transfer to evade the enforcement of the judgment. And as I say, we seek the same orders against Straight as against the English, as were made in the English proceedings. And my learned friend has referred to our application in London. Can I just show you what we're going to be seeking in London?
Yes, please.
If you go to the bundle that my learned friends prepared, bundle B, behind tab 11 at page 93, is the application that is being made in London. You'll see again it's the claimant.
I didn't have 93. The last page is 92.
Ah, okay. May I?
Is that the very last document of the bundle?
Well, they have been, that's been added at the end of, maybe your bundle wasn't updated. If not, I apologise.
May I keep this?
Yes, of course, that's for insertion in your bundle, Your Excellency.
Yes.
So this is an application, you'll see the date stamped 1st of March 2018 by Mrs. Akhmedova against Mr. Akhmedov and a number of co-respondents, number 6 being Straight Establishment. And if you go down to the bottom box, number 3, declaration sought, applicant seeks for declarations that the vessel known as Luna, currently registered in the Marshall Islands, is held by Straight absolutely for the first defendant, the husband. Over the next page, Straight is the husband's alter ego, alternately his privy, and then in relation to Avenger, which is a different entity not before this court. And then orders are sought that Straight is joined to the proceedings forthwith. The corporate veil of Straight is pierced. Any actual or purported disposition of the husband's beneficial interest in the vessel to Straight be set aside. Any actual or purported disposition of the interest in the vessel held by Cubo 2 to Straight be set aside. And then that the vessel be transferred into Mrs. Akhmedova's name and that she holds the beneficial title. And that Straight pay the liquidated sum to the applicant of 260 million euros, or the sterling equivalent, in default of the transfer. An order for the transfer of the sum of 260 million euros by the husband to Avenger be set aside. And so, and then 12, Straight and Avenger jointly and severally liable to pay the lump sum. So that's the totality of the lump sum we've seen in the judgment of the 20th of December. In support of the foregoing, applicant asked for a freezing order in London. So we say it is a misrepresentation of the nature of the claimant's case, that the case here is not an enforcement claim. It is most certainly an enforcement claim. And we're confident that following the hearing on the 21st of March, Straight will be liable to vest the boat in the claimant or pay her 260 million euros, and will jointly and severally be liable with Mr. Akhmedov on the judgment. Those are not matters for this court. That's why this is a separate application. They deal with matters that are not within the jurisdiction of this court. This court doesn't have jurisdiction over the matrimonial claim. It can't force Straight to hand the yacht back or vest the yacht into Mrs. Akhmedova. Only the English court can do that. But we say that once you recognise that there is a claim in this jurisdiction against Straight which falls within the jurisdiction of the court, because it is an enforcement claim based upon the fact that Straight is indeed Mr. Akhmedov and the judgment debtor itself, then we say that it cannot seriously be argued that a freezing injunction is not justified. And indeed, we say that Straight's current tactics are transparently obvious. And my little friend's final and rather surprising submission, not foreshadowed in his skeleton, that you must be careful not to delay your judgment until the 21st of March, is transparently obvious. So this is an attempt to open up a window of opportunity to allow Mr. Akhmedov to deal with the yacht, to defeat enforcement of the English judgment in the time between the hoped-for discharge that is being applied for and the English injunction, which would inevitably, we say, be granted following the order to be made in London on the 21st of March. The court should be astute, we say, not to permit such a cynical abuse of its process. And the court is entitled to do so because there is jurisdiction over Straight. To try to paint Straight as some sort of independent third party, as it does in its skeleton, is to mislead the court. Nothing could be further from the truth. We say it is clear that Straight is a mere creature of Mr. Akhmedov, being funded in these proceedings by Mr. Akhmedov, and accordingly the submissions on the basis of it having some independent existence in paragraphs 17 to 23 of my learner friend's skeleton go nowhere to meeting the actual case made by the claimant and completely miss the point. So Straight tries to make an entirely artificial case and then to answer it. Straight's case before this court is artificial in two respects. First, it suggests that the jurisdiction against the D Ifc Court is purely territorial. It certainly is not. And secondly, it suggests that Straight has some sort of independent existence without actually producing any evidence to that effect. As to the former point, the legal basis for the claim against Straight is not territorial. It is pursuant to the court's statutory jurisdiction to enforce foreign judgments. There is no doubt that the D Ifc courts have jurisdiction to ratify and enforce English judgments, not only against the judgment debtor, but also against, we say, his creatures, who are in effect him. And Straight is in effect the judgment debtor. It is Mr. Akhmedov. And it is not understood, and I think my learned friend made clear that it's not disputed that this court does have jurisdiction to enforce an English judgment. So it's clear that the use of the word territorial is somewhat misleading. The jurisdiction of the court is not territorial. The court can enforce an appropriate judgment from any foreign court. As to the second point, Straight's independent existence, we say there is indisputable jurisdiction to entertain the claim against Mr. Akhmedov. But is the court so powerless as to permit him to escape liability by the simple device of fraudulently hiding his assets from his creditors by transferring them to shadowy entities domiciled in so-called secrecy jurisdictions? Now, Your Excellency will know that there are strict rules in relation to English counsel in making allegations of fraud. But I can use the word fraud in this case because the English courts have already made orders under the Insolvency Act of 1986. And for me to make that good, I need to take up the bundle of authorities on the ex parte. Actually, no, I can do it easily from the judgment of the English court. If you'd be kind enough to go to the original first ex parte bundle, you will find the judgment of the English court in the exhibit to Mr. Tripoli's affidavit. And would you please turn to page 24 of that judgment, and the judge has helpfully set. Sorry, the tab is tab 7. Sorry, it's bundle. It was 1B. Is it tab 7? Sorry, it's 9. It's 8. Is it? 9. It's 8 or 9. I'm sorry. You're all different tab numbers.
Tab 9 is the exhibit to the affidavit?
It's the exhibit to the affidavit. I'd like to take you to page 24 within.
Which starts with paragraph 100?
Page 24 starts with paragraph 100, but I'd just like to take to paragraph 103.
Yes.
Because the learned judge has helpfully set out section 423 of the Insolvency Act 1986. And this is entitled Transactions Defrauding Creditors. And this section relates to transactions entered into as an undervalue. And a person enters into such a transaction with another if he makes a gift to another person or otherwise enters into a transaction with the other on terms that provide for him to receive no consideration, or enters into a transaction with the other in consideration of, I don't need B. C, he enters into a transaction with the other for consideration, the value of which in money or money's worth is significantly less than the value in money or money's worth of the consideration provided by himself. And then 2, where a person has entered into such a transaction, the court may, if it is satisfied under the next subsection, makes an order as it thinks fit, restoring the position, protecting the interests of persons who are victims of the transaction. And then 3, in the case of a person entering into such a transaction, an order shall only be made if the court is satisfied it was entered into by him for the purpose of A, putting assets beyond the reach of a person who is making or may at some time make a claim against him, or is otherwise prejudicing the interests of such a person in relation to a claim he is making or to make. And then, if you would be kind enough within this exhibit to turn forward to the orders that were made in the English court, if you go forward to page 36,
Yes.
so there we have the declarations and the orders that were made. I just really want to focus on Cubo 2 at the moment, because it was from Cubo 2, of course, that Stern received the yacht. So Cubo 2 is the 5th respondent, and we see at page 36, paragraph 11C, the 5th respondent is the respondent's nominee, and the assets held in the name of the 4th respondent belong to the respondent. And then at F, there is reference to a declaration of trust which is found to be in breach of the Insolvency Act, reference also at G and at H. And then if we go over to 37, Cubo 1, Cubo 2 are joined as parties. The respondent and his nominee, in particular the 5th respondent, is liable to pay the claimant £350 million. And at item 14, there is interest there. And there are orders made of paragraph 18 on page 38 in relation to the modern art collection under 423 of the Insolvency Act. And that's probably all I need at the moment to make good this point, that the English court then has found Mr. Akhmedov to be somebody who, it is satisfied, has made orders which attract the Insolvency Act provisions dealing with defrauding your creditors. So the fact then that we have is Mr. Akhmedov has been held by an English court to have fraudulently transferred his assets to third parties. That includes Cubo 2, which has been held to be a nominee and a cipher and alter ego of Mr. Akhmedov. Cubo 2 transferred the boat to Straight, which was in effect then Mr. Akhmedov transferring the boat to Straight, we say, in defrauding his creditors. There is no evidence that any money changed hands. Straight could have brought evidence to this court to that effect. It has chosen what to do so. There is no challenge to the claimant's case that the transfer to Straight was an attempt to defeat enforcement. It is the claimant's case that Straight is a party, essentially, to the fraud on Mr. Akhmedov's creditors, and that is why an order under Section 423 is sought on the 21st of March. So is this court powerless to prevent that fraud? We say the answer is, of course, no. One way in which courts can act is to pierce the corporate veil. And that is a claim that we have made in this court, and it falls within the jurisdiction of this court. Can I show you an English authority on that, Supreme Court authority? It was before you, in fact, on the ex parte hearing.
Before you jump to that point, whether I'm
Yes.
just writing a note in here, you said earlier the people who run Straight are the same people who runs Cubo 2. What is the evidence for that?
You can find that in the. I can do that quite quickly.
Yes.
If you go to the exhibit to Mr. Tripoli's affidavit, and it's page 154. So, if we go to page 154,
What?
to Tripoli's affidavit, these are extracts from the registry.
What's the paragraph again?
Sorry, these are from Liechtenstein. This is 154 of
The exhibit?
the exhibit to Mr. Tripoli's affidavit. So first of all, these are documents that we have from the ship's register as to the ownership at various stages of the vessel. And so we see the current ownership of the vessel is with Straight Establishment, and Straight Establishment is managed by Councillor Trust. We know that, because he is deposed to it, that Mr. Shirley, Dr. Shirley, is a director of Councillor Trust. But if we go to the previous owners of it, Cubo 2, so if you go to page 156, 156, we have the Cubo 2 establishment, and Cubo 2 was managed by Wool Park Trust. We see that at the bottom. Same address as KOTOR.
Wool Park, is it a trust or name or what is it?
No, Cubo 2 is managed by Wool Park Trust. And Wool Park Trust, which we see has the same address as the company managing Straight, which is Council Trust. And we know that Dr. Shirley is a director of the Council Trust. But in fact, Dr. Shirley is also, or was also, a director of Woolpark Trust as well. And we see that on page 157. So the deponent before you, on behalf of Straight,
I can't see Dr. Shirley's name at all.
page 157, at the bottom. Shirley, Dr. Joris Andreas Ignaz. Page 157, bottom left-hand side.
What you said 157.
Yep.
Yes, I see that.
So that shows that
Right.
Dr. Shirley has been involved at each stage of the passage of this vessel between the various offshore entities. So, if I may then go back to the point that I was about to make. This court has the power, as opposed to the jurisdiction, this court has the power to pierce the corporate veil. This court is able to hold that Straight's separate legal personality is to be disregarded, and is able to hold that Straight is entitled to be treated as the judgment debtor, is entitled to be treated as Mr. Akhmedov.
Just like Ubuntu.
Yes, exactly. And I'd just like to show you an English authority on that, a Supreme Court authority. In fact, the most convenient place to find it is in. There's a bundle that I hope you have called Hearing Bundle C, Claimant's Authorities.
I do.
Would you please be kind enough to turn to tab 9 in that bundle? And so we see the decision impressed of the English Supreme Court in 2013. And would you turn on within that to paragraph 27?
Yes.
Which is page 138 and 172. May I just begin reading halfway down paragraph 27, where he's dealing with this question of whether there is, in common law, a power to pierce the corporate veil. And this is Lord Sumption. But the consensus that there are circumstances in which the court may pierce the corporate veil is impressive. I would not, for my part, be willing to explain that consensus out of existence. This is because I think that the recognition of a limited power to pierce the corporate veil in carefully defined circumstances is necessary if the law is not to be disarmed in the face of abuse. I also think that provided the limits are recognised and respected, it is consistent that the general approach of English law to the problems raised by the use of legal concepts to defeat mandatory rules of law. 28. The difficulty is to identify what is a relevant wrongdoing. References to a facade or sham beg too many questions to provide a satisfactory answer. It seems to me that two distinct principles lie behind these protean terms, and that much confusion has been caused by failing to distinguish between them. They can conveniently be called the concealment principle and the evasion principle. The concealment principle is legally banal and does not involve piercing the corporate veil at all. It is the interposition of a company, or perhaps several companies, so as to conceal the identity of the real actors will not defer the courts from identifying them, assuming their identity is legally relevant. In these cases, the court is not disregarding the facade, but only looking behind it to discover the difference. It is to discover, I jumped on that line, sorry, but only looking behind it to discover the facts which the corporate structure is concealing. The evasion principle is different. It is that the court may disregard the corporate veil if there is a legal right against the person in control of it, which exists independently of the company's involvement, and the company is interposed so that the separate legal personality of the company will defeat the right or frustrate its enforcement. Many cases will fall into both categories, but in some circumstances the difference between them may be critical. This may be illustrated by reference to those cases in which the court has been rightly or wrongly to have pierced the corporate veil. Well, this is clearly, we say, an evasion case, but it probably falls into both, because the...
This is right, but what court is supposed to have this kind of investigation then finding?
Which court? This court.
Which court?
This court has the power.
Why this court? Why the court of the merit or court of...
Why does it...
That's what one of the
This court
second
has the power.
defendant argument.
Well, this court has the power for this reason. It is not disputed that the claimant could come to this court to enforce her judgment against Mr. Akhmedov. Now, what Mr. Akhmedov is doing is seeking to evade the jurisdiction of this court by inserting straight within the corporate structure the ownership of the asset, which will be the object of execution when this court gives judgment in favour of Mrs. Akhmedov.
It can be right, however, D2 says this did not happen within the DIFC jurisdiction, nor the asset is located within the DIFC jurisdiction, so the DIFC would involve in such investigation and then as such finding like this.
The DIFC undoubtedly, and it's not disputed, has jurisdiction to enforce a foreign judgment.
Against D1.
Against D1. And the DIFC court undoubtedly has jurisdiction, as was held in the DNB case, even though there are no assets in the DIFC, and even though it is intended that the DIFC judgment will then be taken to the Dubai court for execution through the Dubai court. So DNB has settled that question, the Court of Appeal has settled it. So the next question is, well, what about straight? We say there is jurisdiction over straight because straight is no more than Mr. Akhmedov, and it's accepted that there is jurisdiction over Mr. Akhmedov. And what I'm showing you are the various methods at common law and open to this court for it to hold that straight is no more than Mr. Akhmedov. And the first method that is open to this court is to say we disregard the separate legal personality of straight because straight is no more than a mask. Straight is no more than a facade, is no more than a device inserted between Mr. Akhmedov and the claimant to evade enforcement.
And no evidence to the otherwise.
I'm sorry?
And there is no evidence to the otherwise.
There is no evidence to contradict that. None whatsoever. And indeed, we would say all the evidence is very much the other way. That there is not just an arguable case, but a strongly arguable case, that is so. We would go so far as to say, as we can, I think, now, on an inter-parties, it's unarguable on the evidence that Mr. Akhmedov has taken every step that he can by inserting offshore entities from Liechtenstein, Panama, and other jurisdictions into the ownership of his assets to defeat the English judgment, which is legitimate, and the English judgment is the legitimate subject of proceedings in this court. And
You're just inviting me to investigate over an asset that's not even in my jurisdiction. This is what the D2 says. The asset's not in your jurisdiction. Straight is not in your jurisdiction even.
I am inviting
Not even Mr. Akhmedova in your...
I'm inviting you.
Well, he's not saying you cannot enforce the English judgment, but there is a limit for enforcing foreign judgment. But you should not put your shoes in English or Liechtenstein court and do investigation about companies and assets that you have no link with completely and did not exist in your jurisdiction until today.
Well, first, let me take it stage again at a time. Maybe I haven't made myself clear. There is no question that there's jurisdiction to enforce the judgment.
Right.
And there is no question that that jurisdiction under the DNB case can be exercised even though there is not an asset within this jurisdiction. What I am not doing is asking you to investigate an asset that's not within the jurisdiction.
Yeah, because we can't conclude straight is Akhmedov without investigation. Is that what we're trying to do?
No. We have put forward evidence that straight is Akhmedov. It is important that this court, when enforcing a foreign judgment, recognizes who is the judgment debtor. And we say that there is evidence that straight is the judgment debtor. And so, if straight is the judgment debtor, there is jurisdiction to make the order against him and against straight, against both of them, jointly and separately. That's what we see. And it would make this court powerless. You only have to ask yourself, what's the alternative? So, every time, because what my little friend's suggesting, and with respect, the point that Your Excellency was putting to me...
Well, he said that he gave two different alternatives. If you recall, one of them, you go to the original jurisdiction where the straight registered, which is Liechtenstein, and have another case, as you just did with Cuba 2, or you go where the asset located directly, because the straight has stretched itself to that jurisdiction, but not to D Ifc.
But that doesn't deprive the D Ifc of jurisdiction. We're not
because of DNB. Is that what you say?
Yes. Yeah. It doesn't deprive this court of jurisdiction. What we have to do is look at what the procedure is in this court, and the procedure in this court is very clear. And let me just say what the result of the argument that Your Excellency is putting to me is. If that argument is right, what it means is every time anybody in this court wishes to enforce a foreign judgment, all the foreign judgment debtor has to do is interpose a trust or a foreign company in the structure, and he walks away. That's the result of accepting that argument. Because what you're saying is, then, if you want to come to the D Ifc court to enforce a foreign judgment, forget it.
But that's not true generally. What he's saying, in this foreign jurisdiction, foreign to the court of the merit, only. Well,
No, but that argument destroys DNB completely.
He said, the argument would stretch to that extent if the straight or the mask company is registered within the DFC. That is my investigation, where I have my authority, because it's fallen any kind of jurisdictional category. So
but then what you're saying is that this court is powerless. This court, you defeat the jurisdiction of this court simply by transferring your assets to a Cayman company, to a BVI company, to a Liechtenstein and so on. And I'm going to take it to the English authorities. People have tried that. It doesn't work. And what my little friend's argument means is you can forget about this jurisdiction as one enforcing foreign judgments, because then you just put a sign up saying, here's the way out, everybody. If there's a judgment, if somebody tries to enforce a judgment against you in the DIFC, all you do is transfer your assets to a Liechtenstein-Anstalt. They can't touch you, and the court and the DIFC court is going to refuse to have jurisdiction.
Well, then they too might argue that we're not an international court to first ratify, recognize, and enforce for the sake of the foreign judgment our jurisdiction, and then we can't put our shoes in English court judgments to find what's the relation between straight and thing, and then we cannot put our shoes in another court where there's the asset located and go and search and find who's that asset belong to.
The answer to that is A, this court is an international court, and indeed it says so in the RDC. That's why you can serve out. It says so in terms in Article 9 of the DIFC. This is an international court. That's why you can serve out of the jurisdiction without the necessity to get permission to serve out. And secondly, that runs a coach and horses through DMB, because the Court of Appeal has said in terms that you can use this court's procedures as a conduit jurisdiction. The words of the Court of Appeal itself. And so those arguments would destroy both of those elements. They are inconsistent with the practice and jurisprudence of this court. And what's more, they are a charter to people to evade paying their debts. And they are a charter to people to say, I can defeat the jurisdiction of the IFC court easily now, because I've been told all I need to do is to transfer my assets to a Liechtenstein Anstalt, and they're untouchable.
Yeah, even if that happened after the filing of a claim form.
Yes. I want to take you to the authorities that deal with this potential powerless, because the whole point of a freezing injunction is to prevent such abuses. And can I take you in the bundle we were at a moment ago? We were at tab 9 a moment ago. Can I take you back to tab 6, please? And we have at tab 6 the case of JSC, ETA Bank, and Lions.
Yes.
Within that, can I please take you to paragraph 36?
Yes.
And it says this, the principle of flexibility. The second principle, we're dealing with freezing injunctions now. The second principle is that the jurisdiction to make a freezing order should be exercised in a flexible and adaptable manner, so as to be able to deal with new situations and new ways used by sophisticated and wily operators to make themselves immune to the court's orders or deliberately to thwart the effective enforcement of those orders. In Derby and Weldon, Lord Donaldson stated that the court should not permit the defendants artificially to create a situation where, come the day of judgment, it is not possible for the claimant to obtain satisfaction of that judgment fully or at all. If I just pass down to letter B, in International Credit and Investment against Adham, Mr. Justice Robert Walker stated, the court will, on appropriate occasions, take drastic action and will not allow its orders to be evaded by manipulations of shadowy offshore trusts and companies formed in jurisdictions where secrecy is highly prized and official regulation is at a low level. Can I also take you to another case?
This might be very clearly said that like one regime, like within the United Kingdom, I mean, its enforcement of its judgment within its land, but when you go, I mean, to serve abroad or to do enforcement between over foreign jurisdictions, You need to, I mean, bear in mind the international, jurisdictional barriers and things like that.
But all of this is exactly about that. Can I take you to the next authority, and you'll see what I mean?
Yes, it is.
Can I go back to the bundle that we were looking at before, which was one of the original ex parte bundles?
And tab 9?
Yes, not tab 9 on this occasion. It is page 221 in that bundle, which was, when it was divided into two, it was in bundle 2A. So this is the Pugachev case.
Is it in your
It is
new authority bundle?
no. This actually is the old authority. This is before. This is before you on the ex parte.
Yeah, I see.
And I don't have tab numbers, but I have page numbers.
So do I.
And the page is 221 at the bottom. It's tab 10. I'm extremely grateful. Thank you very much. And
seems like not having that one. I have the one that starts with page 333 only.
yeah, it's
Which I just borrowed from the defendant, D2.
Sorry, this is page 221, and it's internal page 169 of the case JFC. I'm going to have some difficulty pronouncing this.
I see it in the reference, yeah, I do.
Yeah. Well, could I take...
It's like Bagachev or something.
Yes. We'll call it Pugachev, which is the most pronounceable of all the names. And could I begin reading between letters C and D? It is noteworthy in BTA Bank against Solodenchko at paragraph 26, Lord Justice Patton, referring to paragraph 6 of the standard form of freezing order, said, it makes it clear that the respondent's assets can include assets held by a foreign trust or a Liechtenstein Anstalt, where the defendant retains beneficial ownership or effective control of the asset. And then just passing down at letter F, it would, I think, be a matter of concern if a person could make himself judgment-proof merely by setting up discretionary trusts, or as Patton, Lord Justice Patton said, a Liechtenstein Anstalt. So that, I think, with respect, answers the point that Your Excellency was making, that we are looking at foreign entities, but we're looking at foreign entities that have been set up specifically by the judgment debtor to make himself judgment-proof. And the courts are not powerless to allow that to happen, to allow somebody. They look through the foreign entity, whether it's a trust or a classic Liechtenstein Anstalt, and they see the reality of the person behind the mask. And that's what we are asking the court to do in this case. We are asking the person to look behind the mask. And of course, that phrase, the mask, comes from a case that we cited and is in rather colourful terms, but nevertheless sums up the position, we say with great clarity, of why courts are not powerless to allow the sort of abuse that the second defendant is trying to perpetrate in this case. And that is the Jones and Lippman case, which is in tab 5 behind our new bundle of authorities.
Yes.
And there, Sir Justice Russell, as he then was, said at the bottom of what is internal page 836, bundle page 43 of 172, the defendant company is the creature of the first defendant, a device and a sham, a mask which he holds before his face in an attempt to avoid the recognition by the eye of equity. We say those words apply.
Where are you reading exactly that page?
I am reading from the bottom of page 836 of the report behind tab 5, which is page 43 of 172 of the bundle. If you
I'm on the page, yeah. What paragraph you're reading?
I read from the very bottom of the page.
Those
4 lines up. The defendant company.
Yes, that's it. Yeah.
Straight nowhere addresses this case. Nowhere does Straight explain why there is no jurisdiction for this court to hold that it is no more than a device, a sham, and a mask for Mr. Akhmedov in order to hide himself from the eyes of the court. If there is jurisdiction over Mr. Akhmedov, there is jurisdiction over Straight, because Straight and Akhmedov are one and the same. And it's as simple as that when you get down to it. And to hold otherwise would be a charter to allow the sort of abuses that have been referred to in all of these cases, and the sort of abuse we say that Straight and Mr. Akhmedov are attempting to perpetrate in this case. Can I now turn to the Chabra jurisdiction? Because we say that even if you're against me on primary substantive jurisdiction over Straight, arising out of the claim we make directly against Straight, there is nevertheless a secondary jurisdiction, the Chabra jurisdiction, over Straight, which enables the court to make and, in this case, maintain the freezing order. Once again, we say Straight confuses English and DIFC procedures. The Belletti case that my learned friend cited specifically was concerned with whether the parents in that case could be served outside the English jurisdiction. And we see that in bundle, in my learned friend's new bundle, which is, I think, marked bundle B. Belletti is behind tab 10. My learned friend has taken you to part of that. Sorry? Yours, it's not. I'm so sorry. Yes, my learned friend corrects me. It's their authorities bundle, not bundle B. I do apologise. In their authorities bundle, it's behind tab 10.
Page number?
There's no pagination.
I think in the top left of the page.
Behind tab? Oh, sorry, I'm behind tab. Forgive me, yes. It is page 533, paragraph 16. I apologise.
Yes, go on.
And if we look at paragraph 16, however, as Mr. Chambers recognises, even in a case where it would be otherwise appropriate to exercise Chabra jurisdiction over a third party, alleged to be holding assets on behalf of the defendant, the court cannot exercise that jurisdiction unless it can establish territorial jurisdiction over the third party. Where the third party is present within the jurisdiction, so that the court has in personam jurisdiction over the third party, there is no problem. However, where the third party is outside the jurisdiction, this court cannot exercise territorial jurisdiction over him or it unless there is some basis upon which the third party can be served with the relevant claim form or application notice out of the jurisdiction. There is no inherent jurisdiction of the English court to serve a foreign party out of the jurisdiction. Well, there you go. There is not simply inherent jurisdiction in the DIFC court to serve a party out of the jurisdiction. There is jurisdiction in the DIFC court from the rules to serve a party out of the jurisdiction. And so it's an entirely different regime that we're talking about in this case. There is express jurisdiction to serve parties outside the jurisdiction of the DIFC. It then falls to that party to challenge the jurisdiction. The position is, in fact, the opposite to that upon which the Belletti decision was based. Then we say Straight appears to misunderstand the whole nature of the Chabra jurisdiction. It states that the DIFC courts have no jurisdiction to grant interim relief in the aid of foreign proceedings. Now, I make no comment on that because it misses the point completely. The injunction in this case is in aid of DIFC proceedings, not in aid of foreign proceedings. The foreign proceedings, so far as relevant, have concluded and resulted in a judgment on which the claimant brings the proceedings in this court. The fundamental error underlying Straight's submission is that the Chabra jurisdiction is based upon establishing a cause of action against the respondent that falls within the so-called territorial jurisdiction of the DIFC court. But the whole point of the Chabra jurisdiction is that there is no cause of action against a Chabra respondent. And we see that from our earlier skeleton, where we cited the decision of Justice Chadwick in the Al-Fasasi case that I took your Excellency to on the ex parte hearing. And if I could just dig out our original skeleton. Does Your Excellency have the skeleton from the ex parte hearing? There's one error in the bundle B.
Is it in bundle B?
I'm grateful. I'm extremely grateful, my friends.
Say again, where can I find it?
So just give me this. Yes, well, thank you very much. If you'd be kind enough in that skeleton, please, to turn to paragraph 48.
Excuse me, I could not find the skeleton, I think.
Ah, okay. The original, have you been given a copy? I think you were given. Ah, yes, it is. Can I just hand this up again? Is that clean? Yes, would you hand it? Just so you can. I think you were handed a copy this morning, but there's another copy. We can sort it out. This is the skeleton argument. This is the skeleton argument that was placed before you on the ex parte hearing. And I only put it here because it's
right.
A convenient place to see the decision of Sir John Chadwick in the Al-Fasadi case. And we'll see that Sir John Chadwick said this: the court needs to be satisfied of two matters before granting Moreva relief. First, that there is a good reason to suppose the assets in relation to which the freezing order is imposed would become available to satisfy the judgment which the claimant seeks. Secondly, there is good reason to suppose that absent that relief, there is a real risk that those assets will be dissipated or otherwise put beyond the reach of the claimant. The fact that the potential judgment debtor, CAD, has substantial control of assets which are held by a party against whom no cause of action is alleged, the NCAD, the no cause of action defendant, say because the NCAD can be expected to act in accordance with the wishes or direction of the CAD, whether or not it would be compelled to do so, is likely to be of critical importance in relation to the question whether there is a real risk that the assets will be dissipated or otherwise put beyond the reach of the claimant. Because it seems to me the existence of substantial control is not itself enough to meet the first and two requirements. It's not enough that the cause of action defendant could, if it chooses, cause the assets of the non-cause of action defendant to be used to satisfy the judgment. It is necessary that the court be satisfied that there is good reason to suppose that either, one, the cause of action defendant can be compelled through some process of enforcement to cause the assets held by the non-cause of action defendant to be used for that purpose, or two, there is some other process of enforcement by which the claimant can obtain recourse to the assets held by the non-cause of action defendant. So that is the classic formulation of the Chabra
Yes.
of the Chabra jurisdiction, and it's subsequently been adopted in cases in England that, as I think I told you at the ex parte, was a decision of Sir John Chadwick's in the Cayman Islands. And the crucial issue, therefore, is whether there is good reason to believe that the claimant will be able to invoke some process of enforcement that will lead to recourse against the assets of the non-cause of action defendant. So, if we're dealing with a defendant against whom no cause of action to make the order lies, that cannot fall within the Judicial Authority Law Article 5A1, which is all about claims, actions, and appeals. So jurisdiction in Chabra cannot be under Article 5 of the Judicial Authority Law. So what then is the jurisdiction in Chabra? We say that it is found in Article 32B of the D Ifc Court. And you will find Article 32B in the bundle we were looking at before, which contains the Judicial Authorities Law, and you'll find that at page 694 of that bundle. And now we're looking at the powers of the court. And the court has the power to make orders and give directions as to the conduct of any proceedings before the D Ifc Court that it considers appropriate, including 32B, injunctions, including requiring an act to be done. And over the next page, 695, F, orders made in the interests of justice. So what we have in this case is a situation where there are current proceedings before this court, and this court has the power under Article 32, either B and or F, to make orders in aid of those proceedings, to make injunctions in the interests of justice. And we say that Chabra jurisdiction is to be found there. And the order in the present case would be an order in the proceedings against Mr. Akhmedov by way of injunction in the interests of justice. So even if the court were persuaded, we would say wrongly, that it has no direct jurisdiction against Straight. It would still have jurisdiction to make a Chabra order, and so the injunction must stand until the proceedings against Mr. Akhmedov are concluded one way or the other. We accept that the jurisdiction to make a Chabra order is entirely discretionary. And my learned friends could have argued that the court shouldn't exercise its discretion to make a Chabra order. To do that they would have to rely upon facts upon which that discretion is based. There are no evidence before you in relation to that, and so we say the Chabra order should stand. Finally, therefore, I turn to the allegation of non-disclosure. We say that is an allegation that should never have been made and is made on a wholly false basis. The complaint is set out at paragraph 34 of the skeleton, as expanded by my learned friend, and it is that the court was not told that Straight was likely to raise the point that there was no territorial jurisdiction. That is simply playing with words. The court was told, whether you call it substantive or territorial, the court was told that there were going to be issues about the jurisdiction of the court over Straight. And indeed, it is accepted that the court was informed that there was a potential jurisdiction challenge. And indeed, it was informed, we say, in no uncertain terms. We said that we recognized there would be arguments about jurisdiction. There is no obligation on a party to raise the misconceived and wrong distinction that Straight might make between substantive and so-called territorial jurisdiction, which simply has no meaning in D Ifc law. It's also said that the claimant ignored the Nest and Carafi cases. But in fact, those cases don't relate to the issues in this case. They are relied upon by Straight to say there is no parasitic jurisdiction, as they call it, just because there is a good claim against Mr. Akhmedov. That's not what the claimant is saying in this case anyway. The claimant is not saying that just because there is a claim against Mr. Akhmedov, you should join Straight. What the claimant is saying is Mr. Akhmedov is Straight, and Straight is Mr. Akhmedov. They are one and the same. And so the Nest and the Carafi cases are completely irrelevant. It's also said that the claimant should have disclosed the Belletti case. But that argument, we say, based on Belletti, is also misconceived. The jurisdiction in Chabra cannot be based upon Article 5A1 of the JAL because it is against a party against whom there is no cause of action. And so it must be based upon the court law. And so that is a fanciful argument. The allegation of non-disclosure is therefore a wholly artificial and false argument. The court was clearly informed that there was an issue as to jurisdiction over Straight, and so the duty of full and frank disclosure was discharged. It certainly does not extend to speculating what unsustainable defences a defendant might dream up, and the courts have made this clear on a number of occasions. There are a couple of authorities that I'd like to take you to, if I may.
Please.
They are in our new authority bundle, which we've called C. Can I take you to tab 10 in that bundle, which is an extract from Mr. Stephen G's book on commercial injunctions. And it's internal, it's bundle page 171 and 172. It's the penultimate page in the bundle itself. Next to the number 9-007, the applicant must identify any defences which, although not yet taken, would have been available to be taken by the defendant had he been present at the application, provided that 1, the defence is one which can reasonably be expected to be raised in due course by the defendant, and 2, the defence is not one which can be dismissed as without substance or importance. For example, an argument based on a misconceived interpretation of a statutory provision. We say that the arguments raised by Straight today fall fairly squarely within the misconceived category, and therefore there was no duty to raise those misconceived arguments. Can I take you also within the same bundle to tab 3, the case of Electric Furnace against Sellers Corporation of America, and within that tab to page 29 of the law report, or page 26, of the bundle, numbering top right-hand corner, where Lord Justice...
Would you please give the reference again?
Yes, I'm so sorry, I took it too quickly. It's same bundle, tab 3, and it's internal page 29 of the law report.
I got it, yeah.
And Lord Justice Slade, in the English Court of Appeal, said this next to next to the number 5. In my judgment, this was putting the point rather too high. I think it would be unreasonable to expect a plaintiff preparing his evidence in support of an application under Order 11, Rule 1 to anticipate all the arguments or all the points which might be raised against his case. In the context of a case such as this, where there is no deliberate intention to mislead the court, I respectfully agree with the observations of Mr. Justice Carr in B-plea Exploration against Hunt. In my view, a failure to refer to arguments on the merits which the defendant may seek to raise in answer to the plaintiff's claim at trial should not generally be characterised as a failure to make full and fair disclosure, unless they are of such weight that their omission may mislead the court in exercising its jurisdiction under the rule and its discretion whether or not to grant leave. We say that it cannot be suggested that the court in this case was misled. The court was made aware that there were issues about jurisdiction. The court was aware that Straight was a Liechtenstein entity. It was never suggested that there was jurisdiction over Straight, save on the basis that it is Mr. Akhmedov's alter ego and cipher. It is fair to assume in this court that this court is well aware of the terms of Article 5 of the Judicial Authority Law. The third point, or third authority that I'd just like to take you to finish on, if I may, we say that Straight's manufactured allegation of non-disclosure is typical in cases of where defendants are desperate to crawl out from under freezing injunctions when they have no other grounds on the merits. The courts are well aware of such behaviour and have condemned it. And again, it's a dictum of Lord Justice Slade, this time in the Brinks-Matt against Elkham case, which you'll find in the same bundle behind tab 1. And this is internal page 1359 of the law report, page 10 of 172 of the bundle. And if I may just begin reading between letters B and C of that report at 1359. Nevertheless, the nature of the principle, that's the full and frank disclosure principle, as I see it, is essentially penal. And in its application, the practical realities of any case before the court cannot be overlooked. By their very nature, ex parte applications usually necessitate the giving and taking of instructions and the preparation of the requisite drafts in some haste. Particularly in heavy commercial cases, the borderline between material facts and non-material facts may be somewhat uncertain. While in no way discounting the heavy duty of candour and care which falls on persons making ex parte applications, I do not think the application of the principle should be carried to extreme lengths. In one or two other recent cases coming before the court, I have suspected signs of a growing tendency on the part of some litigants against whom ex parte injunctions have been granted, or their legal advisors, to rush to King against Kensington income tax commissioners. Principle as a tabula in naufragio, that means a plank in a storm, alleging material non-disclosure on sometimes rather slender grounds as representing substantially the only hope of obtaining the discharge of injunctions in cases where there is little hope of doing so on the substantial merits of the case or on the balance of convenience. Now, while Lord Justice Slade there was talking about material facts, we say his observations are equally apposite in trying to manufacture allegations of failure to raise supposed legal defences. And so we say that Straight's jurisdiction challenge in all the circumstances must fail. We say this was the return date for the injunction. The hearing was fixed at Straight's request. It has no excuse for not bringing its full challenge to the injunction in one go today, or indeed on another date in the very near future convenient to it. We say that the injunction must now remain in place until trial or further order based upon a material change in the circumstances. A second return date is a logical nonsense. There can only be one return date. The court can't stop Straight making such further applications as it wishes, but unless they are based on a material change in circumstances, the court, we say, should not entertain them, as there would be that would be yet another abuse of process. If they do try to bring a further challenge, we will have to address that if and when such application is made. May I just check with those behind me that I've covered the ground, because I've reached the end of my prayer. Yes, the only additional matter is the one that my learned friends sprung upon us this morning without warning and not in their skeleton, about the execution letter. That I'm not in a position to deal with that today. And that is not a mere forensic position, because it depends, in fact, of course, upon Dubai legislation. And it depends upon the meaning in Arabic, ultimately, of that legislation. Because, of course, judicial authority law is a Dubai law, not a D Ifc law. And it depends upon the jurisdiction of the Dubai courts, which we would have to look at. We note that the letter from this court made it clear that this was a provisional order. And we know that the order that was made by the Dubai courts was under Article 252 of the Civil Code. And so, without arguing the point fully, because I have not come along to argue it and was given no notice of it, it wasn't the execution of the judgment in any event. It was the reciprocal acknowledgement of a provisional order and the reciprocal grant of a provisional order under Article 252, rather than the execution of a judgment. And I would need more notice and more time to develop those arguments as a matter ultimately of Dubai law rather than the IFC law. So I do reserve my position on that. Had I been given some warning of the argument, I obviously would have had the appropriate research done, and I could have been assisted by Dubai lawyers on that.
Well, I see your point. I even asked D2 if that was even initially formed in their submission, but the answer was, I guess, almost no.
No. So unless I can assist the court further, those are my submissions.
Thank you very much, Mr.
So
I think you have just finished this morning.
well, I do have a right to reply, but I think we come full circle because, as I said this morning, the whole application boils down to a very simple point. And my learned friend says his terminology is now jurisdiction, stage 1, power, stage 2. So I can just talk about jurisdiction. And the simple point is that there is and was no jurisdiction against the second defendant. The only basis on which that is based is the English judgment, and you were taken to the English judgment. One thing that my learned friend couldn't say to you or suggest to you is that that English judgment was against the second defendant. Now, in my submission, that is the end of the matter.
He said a great deal about the flexibility or power of the court in many ways, and English cases where there is jurisdiction against a defendant, what the English court does in those circumstances. None of those cases relate in any way. And essentially what the claimant is asking the court to do is asking the wrong question. The question is very clear: does this court have jurisdiction over the second defendant? The only basis involved is the English judgment, and that judgment doesn't give jurisdiction. In my submission, that is the end of it. One doesn't go any further forward. I do want to address, in case there's any confusion about it, I do want to address what my learned friend says and the way he says it. The first thing he said was, the factual basis is not in dispute. Well, we've made it very clear that the first stage is jurisdiction. That is neither here nor there, whether the factual basis is in dispute. The question is, has the claimant established jurisdiction over the second defendant? And the answer is no. He says, well, our cases that my client is no more than a cipher. It is used only for the sole purpose of evading judgment. He says all those prejudicial comments. But that doesn't give territorial or any jurisdiction over the second defendant. The question is, how does one get to that conclusion? The only way he does it, and the only way he applies the ex parte, and the only way he does it is on the basis of the English judgment. Unless he can show that judgment is against the second defendant, it fails. And he's implicitly acknowledged that the judgment isn't against the second defendant because he says, I'm applying in England on the 21st of March, and I hope and expect that I will get judgment. That's a very different case. So his first point about the factual claim is neither here nor there. And he did a great deal about showing your Excellency that under Cubo 1, Cubo 2, the English court gave judgment against those entities. But that isn't the point. The point is there a judgment against the second defendant today? Was there one of the ex parte application? There wasn't. End of story. He says you can't trust us. Well, again, neither here nor there. The question is there jurisdiction? Answer, there isn't. That was his first point. So he says, well, we haven't come and contested the facts. We've contested the necessary facts giving rise to jurisdiction, and that depends on the English judgment. They say, their second point is, it's not in dispute that if the wife gets judgment against the second defendant, then there can be enforcement by the wife. Well, in a sense, that is true. The question will be whether the judgment they obtain is recognised by this court. But yes, we accept, for example, that they have got a judgment against the husband. We're not disputing the position in relation to the husband. If they subsequently get an enforceable judgment which is recognised by this court, then they would be in a different position and we'd have a different argument. But they haven't done that. So there's nothing in the point of saying, well, if we get a judgment, then there may be jurisdiction. They haven't got a judgment and there is a jurisdiction. That's the test. That was his second point. Then he said, there is formal invalidity of our claim, and this, I think, was repeating the point in his written argument, that there's no evidence. And as I say, that doesn't take them anywhere. Firstly, there is evidence in our application, but even if we hadn't served an application, that's neither here nor there. It's for him to show jurisdiction, and he hasn't. He's failed to do so. Then he made some submissions about the DIFC being a unique court. And of course we accept that the DIFC is unique in one sense, although, as he said, copied by other courts. That is true. And he says it deals with jurisdiction in a unique way. And he says service is decoupled from jurisdiction. We accept all of that. All of that is true. But you still have to show jurisdiction by reference to the statute. The fact that in England you can get extra jurisdiction by service out and by bringing in other people by method of service doesn't help my friend. It's actually against it. The DIFC court's jurisdiction is defined in the statute, and that statute must be followed. And he must explain why and how he gets jurisdiction of my client. And with respect, he hasn't done that. He says that you have to make an application and set aside jurisdiction. That may well be the case. That's exactly what we're doing now. This is our first opportunity to contest jurisdiction, and we do so. And our evidence does go to jurisdiction. And he says, well, you haven't given the court an answer to our claim that you're a cipher. But again, that is a claim. The jurisdiction is asserted on the basis of the judgment. And the judgment isn't against my client. The fact that he's got a claim, he says, I have a claim in England. I showed you the pleadings in England. He showed you the claim of the DIFC, the particulars of the DIFC, that he had a claim. But the point is, he doesn't get anywhere unless he establishes that he has jurisdiction over the second defendant now, not that he has a claim. And so we don't need to answer the cipher allegation, because he doesn't get to first base, he doesn't get to jurisdiction, because he can't say you're a party to the judgment. Then his fourth point is an assertion that what we say is misconceived as a matter of law. Now, we simply don't follow that. It's very, very clear. He says, as I understand what he said, is you do look at Article 5 of the Judicial Authority Court. There is a distinction between jurisdiction and power, and we accept all of them. You do. That's exactly what we've said. You look at Article 5. Do we fall within it? In a sense, this case is much easier than many cases because you're not concerned with A to D. You're only concerned with enforcement. And if he had a claim under one of the other heads, then he could bring it under the other heads. But he hasn't done so, and he can't do so because it doesn't fall within A to D. He then asserted a few things about essentially prejudicial claims, which he says that we're in breach of your Excellency's order because we haven't told them where the funds came from. But it's not a breach to be paid by a third party, and we are being paid by the legal fees are being paid for by a third party, so the order doesn't apply. And
what are the evidence for this?
Well, the answer is we don't have the evidence because we've only heard today that he says we're in breach. That's not in the skeleton argument or in correspondence. And they've known that we represented for some time when we fixed the hearing. So we haven't dealt with that. So it's, in a way, Your Excellency, it's the other way around. He says that there's a breach. In order to do that, he must show evidence. And the only evidence he says is that we're appearing today. And that's not enough.
Well, you have taken us to the order, and he has taken me to your affidavit.
Yes.
And he said it's no evidence where the money comes from.
Well, yes, he does, but the order only bites if it's money of the second defendant. If it's being paid by another party, there's no breach of the order, and there's no need to tell them where the money is coming from. So it's not a breach.
You're not giving evidence now.
No, I'm meeting a case that I heard for the first time orally.
And why he not allowed to do the same way?
I understand. The other thing he said was he took you to the Liechtenstein order. He says I'm on very dangerous ground because there was a breach of the Liechtenstein order when the vessel was transferred. But in fact, their own case, in their own evidence, in Mr. Tricole's witness statement, paragraph 51.3, is that the freezing order didn't cover the vessel. What it covered was the art collection and the money. It didn't cover the vessel. And so we said there's no breach of the order, of the Liechtenstein order at all.
There isn't a general statement about assets and money and things.
Well, let me take you to
we can't include the vessel.
Let me tell you what he said, what they say in their evidence. If you go to their ex parte bundle, I think it will be in your Lordship's bundle at tab 7. If you see what they say in the records. It's either tab 8 or tab 7.
Page number?
It doesn't have a separate page. It's the first affidavit of Mr. Tricole. It's not the exhibit. To your Lordship to go to same point. It's in 2 paragraphs. If you go to paragraph 35.4.
I couldn't find it. 1 second.
I'm sorry, it's the affidavit itself, the first affidavit from Mr. Tricoli. In my bundle, it's tab 8, but maybe tab 7 in your Excellency's bundle.
The bundle you just passed to me this
Bundle
morning?
bundle one of the, just the I think Mr. Black passed it up.
You said behind tab 1?
It should be tab 7 or 8, I think. Here's a copy.
Yes, I got it.
Oh, you got it?
Yeah.
35.4.
Yeah, the Liechtenstein freezing order.
Yes, exactly. On the 28th of December, the wife obtained the Liechtenstein freezing order from the Liechtenstein court against Cubo 1 and 2, preventing them from transferring or otherwise disposing of the modern art collection and the cash assets in the amount claimed. That's also repeated exactly the same wording at 51.3.
And you're saying cash assets doesn't cover the vessel?
Doesn't cover a yacht, no, it's cash assets, exactly. It's very far removed from the issue that Your Excellency has to decide. Because the issue Your Excellency has to decide is whether there's jurisdiction.
And is this, what's in the affidavit, is it the same wording of the order?
No, it's an explanation of what the order covers, and we say that explanation is right. That's what they say, and that's what they said to Your Excellency in the ex parte application. This was the evidence in the ex parte application.
I see your point.
So I don't mean to interrupt Your Excellency, but since we have
Yes, Dave.
since we have the affidavit open, I wonder if you would also have a look at paragraph 50.
Yes, I'm very happy. Fifthly says, the wife has been forced to engage lawyers and commence enforcement proceedings in various jurisdictions where the husband took or sent his luxury assets and money in breach of the various freezing orders and judgments. Yes, it does say that. But the point made against me was that we were in a breach of it was a breach of the order by Cubo to transfer.
Yeah, Mr. Black, he was referring to that. Yeah, he said they are not a breach of Liechtenstein order.
Yes, and it's not my clients that are in breach. Again, it's Cubo that's in breach of the order. Not my clients. So, in a sense, we're very, very far removed from the issue that Your Excellency has to determine. But it's not correct to say that it's as straightforward as that. Their own evidence was that order did not apply to the yacht, only to the modern art collection and the assets. Then he said, yes, what he said is Article 5 of the Judicial Authority Law is about claims, and that therefore there is jurisdiction. Now, I don't follow that, because the only jurisdiction that's being asserted is the enforcement of the English judgment. He doesn't bring a claim under any of the headings of 51A8D. And if I just remind you of his skeleton, so in the same bundle at tab 1, how he puts the case, which is, if you just tab 1, it's the skeleton on the ex parte application.
No, I think I didn't have that. I've just seen it in paper.
Yes.
Anyway, go ahead. Give me the reference.
It's paragraphs 33 to 38.
Yeah.
And it's all about the legal principles. And it says the D Ifc Court's jurisdiction to enforce a foreign judgment. the whole basis of the case advanced before the logical ex parte was that the court has jurisdiction to determine an action for the enforcement of a foreign judgment. So it's all on the basis of the enforcement of the English judgment. It's not a claim being brought under a separate claim under 51A, A to D, or any of them. And in fact, what my learned friend said was, and I'm sure I heard this correctly, he says he didn't need the English judgment. He doesn't need the English judgment. The whole basis of the case put before you on the ex parte was on the basis of the English judgment. So if he doesn't rely on the English judgment, he has nothing at all.
No, quickly. I think
You did say in those
You may come back on Mr. Black.
The English judgment on 21st of March. You don't rely on any English judgment on the 21st of March.
There is no 21st of March yet, Mr. Black.
Right. Well, he doesn't rely on, but again,
So I wouldn't need the 21st.
oh, he's saying, right, so now he says, although he has brought a claim, he says, in the D Ifc Court and in the English court for judgment, he doesn't need that. That's his case now. He doesn't need to do that. And that would only be the case if the judgment were already against the second defendant. Well, he says, which it is. It isn't. It isn't against the second defendant. Nowhere when he took you to the judgment did you see any suggestion that the second defendant was party to the judgment. And indeed, the same position applied in relation to Cuba. You get judgment, he went and got judgment against Cuba and obtained that judgment. He didn't say, I don't need that judgment. And when he goes to the English court, we'll have to wait and see what he says to the court. But it would be a very surprising thing indeed if he said to the English court he didn't need the judgment. But he was making the application anyway.
You're not accepting service, isn't it, for the engagement? Or you're not instructed.
Certainly not.
You're not instructed.
I think there's one thing that's clear in this case, and that is we don't expect jurisdiction with anything. So what they say is, they now say, well, they don't need this in the judgment. Presumably they don't need the claim in the DIC. They say, you look at the judgment. I've shown you all the authorities. It's very clear. They need to show that there's a judgment against my client, and they simply don't have it. It's not a matter. It doesn't matter how confident they are that they might get judgment in the future. That's neither here nor there. He then dealt with delay in judgment, and he says that what we are doing is attempting to open up a window to allow the husband to deal with the yacht. Now, we have nothing. I'm not making submissions on behalf of the husband. I'm not making any submissions about what he can or can't do. They say they have a judgment against the husband.
Well, he's addressing the risk of dissipation anyway.
Yes, exactly. But the point is, the issue for the court is, should they have had this order in the first place? They should, in my submission, have told Your Excellency the issue, exactly address the issue about jurisdiction, as it's now accepted that the jurisdiction was paramount. Did they have jurisdiction over my client? And the only and obvious answer to that question is no.
And he's still not saying that.
He's still not saying no. He's trying now to say the judgment of the English court is against my client, but it plainly is not. He says under this heading, we're a mere creature of the husband. Again, that's a claim, not a judgment. And he says that it's a purely territorial jurisdiction. But we say it's purely territorial. He says the position of the D Ifc is different. It is true, it is different in one sense. There's no need for service out. You still have to look at the jurisdiction under the rules to see whether any of those rules are satisfied. And as I say, it is only judgment that they rely on. Then he says, then he showed Your Lordship that they obtained judgment that they against Cubo 1 and Cubo 2. But on his analysis, that wouldn't have been necessary. He wouldn't have needed to get judgment against Cubo 1 and Cubo 2, because his case is any entity anywhere in the world that assists the husband in any way in terms of assets is party to the judgment, to the English judgment. But that simply is not the case. Simply is not. On his analysis, it must be that he didn't need to get judgment against Cubo 1 and Cubo 2. And in my submission, it's obvious that that's not the case. And then he showed you, he went to Crest, showed you English cases that the English court can pierce the court of Preparatory. Well, yes, the court may well be able to pierce the court of Preparatory. Again, that is a claim that would be determined in due course, and we say that would be a claim that would naturally be determined either in Liechtenstein or in England, not this court, who hasn't been determined.
According to the jurisdictional rules.
Exactly, according to the jurisdictional rules of this court. So going to lots of English cases to say that the English courts can look through, these are all about the substantive jurisdiction. This is all about the power of the court. It's not about the jurisdictional court. The English cases are all cases which concern, they have jurisdiction over a defendant and the powers it has over that defendant. And it has very extraordinary powers, very flexible powers.
So you're saying jurisdiction first, power come next?
That's exactly the point. It's a very simple one. And we keep coming back to it. Stage one, you have to pass stage one, they haven't passed stage one. You don't get into stage two. So all of the citations of the cases about evading judgments and the flexible remedy don't go anywhere. And your Excellency asked two questions at this stage. Which court, you said? And Mr. Black said, well, this court. No, not this court. Not this court under its own rules, and obviously not this court, because they brought the proceedings in England, and my clients are based in Liechtenstein. So there are alternatives, but it's not this court. And your Excellency then said, but surely if you're saying that the husband and the second defendant are one and the same, they're a cipher, they're the same as each other, that needs investigation. And you're absolutely right, because it's a claim. It hasn't been determined by the English court, or indeed any other court. And they haven't got any jurisdictional basis for that claim being brought here. That's end of the story.
And you're saying that not our jurisdiction as well, because it's a power, it can't start after we find jurisdiction.
Exactly. You can't exercise any power. However broad and flexible and extensive the court's powers are, they can only exercise them if they have jurisdiction. It's a very simple point. And that's why we could say it does fall down for a failure to make full and frank disclosure, because if that had been explained to Your Excellency, it's a straightforward point. It wouldn't take long to explain that. All the points in the skeleton about power are neither here nor there unless you can establish jurisdiction. It's very, very simple. So for example, Mr. Abiyazo, I acted for Mr. Abiyazo at one stage in the proceedings. The court had jurisdiction over Mr. Abiyazo, and it could exercise and did exercise some very extensive, flexible power. But that was because it had jurisdiction. There was no suggestion that it didn't have jurisdiction. Then Shadler. I won't repeat myself, but it's very, very clear. The cases are clear. Benetti makes it clear. It's the same point. Of course, we accept the whole point of Shadler is a non-cause of action defendant. We don't dispute that. But you have to have jurisdiction. And so you can't get round the rules of jurisdiction. The court cannot exercise its powers, even on a Shadler basis, unless it has jurisdiction over the defendant. And there are bases on which the court can have jurisdiction over a DIFC body, for example.
What about the DIFC law, Article 34, that Mr. Black?
That is, I was about to take you to that. That doesn't help you. It says power in terms. Of course, the court has the power to exercise, to grant an injunction. I'll just I had a reference. Yes, it's tab 16 of the authorities bundle, their authorities, which is I think it's called bundle 2B. It's their authorities bundle on the ex parte. Tab 16 of that bundle, the DIFC court report. Page
694.
Yeah. And the wife was very careful to make a distinction between jurisdiction and power. And that's a sensible jurisdiction. There's a sensible distinction between the two concepts. But when one looks at 32, it's clear what that is. It's under Chapter 1, Practice and Procedure. And it's obvious in my submission that what this is dealing with is the court's powers once it has jurisdiction. it doesn't give a jurisdiction over any defendant. And if one looks at 32, it's expressed in terms of power. The D Ifc Court has the power to make orders and give directions as to the conduct of any proceedings before the D Ifc Court that it considers appropriate, including granting injunctions at B, requiring acts to be done, and orders made in the interest of justice. Of course it has those, but that presupposes it's got jurisdiction.
You saying the court cannot grant any of A to
No.
G
Yes.
without jurisdiction in the first place?
Absolutely. Because otherwise, you could exercise this, if that were right, you could exercise this against anybody in the world, any entity, any person, with no connection whatsoever to the DIC, because you have the power to grant an injunction. We don't dispute there's a power in the court to grant an injunction, or indeed any other order made in the interest of justice. But the question is against whom? Against whom? And that is a question of jurisdiction. And you cannot give the court such... This would be... Sometimes people complain about the long-arm jurisdiction of the United States interfering in countries where it should.
Oh, this is longer.
And this is way, way, way beyond that. Way beyond that. This will be the greatest jurisdiction of any court in the world. Because it can simply...
Oh, so you agree with Mr. Black? Should be longer.
I so do not agree.
That will extend to your client.
On this analysis, though, if Mr. Black is right, that will be the consequence. And
Right.
it's plainly not right. What then... Yeah, so Mr. Shifty quite rightly points out that under 32 you also have the power to issue contempt orders. You have a contempt jurisdiction against anyone in the world for failing to obey the orders. So it's that, although Mr. Black says that our whole argument is completely misconceived, with respect it's the other way around. It's very straightforward. And then, so on full and frank disclosure, I'll just take you to all our authorities are in the skeleton. I don't want to labour this point more than I should, but if I just take you to the extract of E and G, so here's second authorities one, so the one which is paginated up to 170.
The colourful one.
Yeah, just the very penultimate page of the bond. Now, I want to make it clear to Your Excellency, what I'm not saying is that Mr. Black had in the ex parte application to get up and spend 2 hours, as I have done, explaining all of the case. Absolutely not. What he was obliged to do, if you look at G, paragraph 9007, the applicant must identify any defences which, although not yet taken, would have been available to be taken by the defendant had he been present at the application, provided the defence is one which can reasonably be expected to be raised in due course by the defendant. Now we say the most obvious and striking defence, stage one, is there jurisdiction over the second defendant? And that, to be fair, that wasn't done in Tubbs. What they said was there would be an issue about jurisdiction, but they said they had a good arguable case and they had substantive jurisdiction. They did not take the point I'm making to your Lordship today. And if your Lordship is with me, that is a very obvious, very basic defence to the order. So we do suggest that if your Excellency had been alerted to this point, it would have been one that you would like. You asked quite a few questions about starting, indeed about jurisdiction, bringing in parties and so on. If this had been alerted to your Lordship, it would have, in my submission, changed the nature of the questioning about why they could get an application order against the state. Finally, I just want to take you to one last point, which is the letter of execution. And what they say in relation to that is, oh, well, it's all taken them all by surprise and they can't deal with it. We raised 3 points. That the judgment wasn't against the second defendant, it wasn't final, it wasn't ratified. I just want to show you how they dealt with it when they were before you on the 8th of February. And if you go, please, to page 9 of the skeleton, so that is in bundle 1, the ex parte bundle, you were looking at a little moment ago. in tab 1. So it's the without notice application for a freezing order. Paragraph 39. This is page 9. And what is your
9 behind tab 1?
it should be the skeleton without notice application.
Yes, I got it.
You've got it. If you go to page 9, you'll see procedure for execution in Dubai. And what they said at 39 was once the court has entered judgment for the enforcement of a foreign judgment, that judgment, a local DIFC judgment, can be taken for execution in the Dubai courts. And then it says Article 7.2 sets out the procedure, and they then set out the procedure, and you'll see they say in A, the judgment is final and executory. And then at 40 they say the procedure for seeking execution outside the DIFC is set out in rules 45.18 to 45.24 of the rules of the DIFC courts. So they did say to your lordship the basis upon which there could be execution, but they don't answer our 3 points. It's not the second defendant, it's not a final judgment, the freezing order is not a final judgment, and it hasn't been ratified. So although they told you, Your Excellency, that that is the process, that wasn't the process that they followed, because they didn't seek to enforce the judgment. What they sought to enforce was the freezing order, which is not a final judgment. So it's surprising that, having told Your Excellency what the position was on the ex parte application, now we've raised it and said, well, why did you issue the letter that you did? They can't explain that without having more time. It's a surprising concept. Yes. And then just in terms of the... I know that in my submission, fairness or unfairness doesn't arise in this case. It's simply an application, a black and white application of the rules of this court. And if one applies the rules of this court, one doesn't get to the second defendant. But we do say that actually there isn't any unfairness, because the wife can apply in Liechtenstein. She said that she can apply in England for a judgment, and she has access to justice in those jurisdictions. This is not a case where no other court would act, and without the help of this court, nothing can be done. Indeed, as Your Excellency appreciates, the asset isn't even in this jurisdiction. It's in the local jurisdiction of the local courts. So that was all I was going to say, unless Your Excellency has any questions.
Thank you very much.
Your Excellency, I'm sorry, I don't try and read from my skeleton, but with respect to him, and it was probably misdirected, you went to the wrong part of it. And so just to correct that, if I may, because he read the part that was dealing with the execution of the judgment of this court, but at paragraph 70 of page 18 of the skeleton, we dealt with the freezing injunction. And we did not suggest that the freezing injunction would fall under the regime for execution of judgments.
Paragraph 18?
Paragraph 70 on page 18. And we said that it was our intention to seek an order from the Dubai courts to attach the vessel pending determination of the claim. It's the intention to refer the Dubai courts to the freezing order made by this court and rely on that order in support of her submission that a pre-judgment attachment should be granted. Working together, the IOC and Dubai can prevent the defendants from removing the Luna from the prospect of enforcement of this court's judgment. So that was the wrong part.
I'm very grateful, but just to remind Your Lordship, could Your Lordship go to Bundle B at page 91? Because that is what they actually, that is the letter of execution that they actually obtained. refers in terms in that letter to the letter of execution of a provisional order. It's against the husband and straight corporation, and it says in terms that it's upon the request of the applicant, subject to Article 70.2 of the Law 2004, we send a provisional order into the court of
But it's sorry, but it's just a mere letter that referring to the court order, to the Dubai, to Dubai court to enforce what's in that order. You know what I mean? So this letter wouldn't be a final or a very official reference of things to be taken. Or discussed in formal. It will be the order.
Yes,
I think the only purpose of this letter is to say there is a DFC order, need to be enforced in Dubai court, and that's the order. The order is attached and it's translated. That's it.
Yes, but what my own friend says is that I have misunderstood because they weren't. I took you to their skeleton, which says they were seeking to enforce the judgment under Article 7.2 of the JAL law.
And he said it is broader than that. We discussed the other thing as well, which you can see in the other.
Right. Although, yes, but the letter itself says it's under Article 7.2, and for that to happen, it needs to be a final judgment. It's not an attachment. It's a request under Article 7.2.
Well, again, this is not a judgment. It's whatever comes in it. Article 7.
Yeah.
Yes.
So that.
Yeah, I don't know. I doubt that. Like the claimant have seek the letter to be written in this way. I think maybe one of the court
It may.
templates.
Yes. It may.
But I think the final thing is the court finding and the court order.
Yes. Well, exactly. But the problem is, of course, because this is an official letter.
I tell you what. Why the freezing took place? Because the court decided that.
Yes.
The court decided there will be freezing, and now according to what? It's the reference is the order. You know what I mean?
Yes, I understand. But of course, this has an impact because it's obviously given great authority by the local courts and it's used to achieve an end. So it's just, in its terms, it's not right.
Well, I see your point now. I see your point now. It's something you might raise with the other court, maybe.
Yes.
If they listen to it.
Very good.
Thank you very much. You done, Mr. Black?
Yes, Your Excellency.
Thank you very much, all. Right. I believe I've heard enough. And I'm not ready enough maybe to deliver my judgment today. I always say Sunday. Is that okay for everyone? It's not too long, I guess.
Yes.
You have my judgment Sunday. Yes,
May I don't know whether I know my other friend and I are both leaving the jurisdiction tonight. Would you excuse us if we're not present on
yeah,
site?
for sure.
Actually, again, I personally will actually be back here on Wednesday, but I don't know whether that's too long to wait.
Yeah, we would certainly prefer Sunday.
Yes.
Sunday. Thank you.
All rise.
You're going to be in London on
I'll be in London on Sunday. I'm going to stay with you.
Yeah, well, I will.
Yeah, exactly.